Hi, my name's Andrew Thompson. I've been joined by my colleagues Anand Singh and Mohammed Mutazeb to talk about natural damage and weather and its implications for real estate. Please continue to watch or listen to get the latest insights from my expert colleagues.
We're going to talk today about a very important and timely topic, the impact of natural disasters and weather on real estate and how that will impact investors, as well as residents in that area. So I'll start with you, Mohammed. Can you sort of go through for me the basis of liability for physical damage under the Civil Code and how that applies in practice?
Good morning, everyone. Thank you, Andrew, for this question. Actually, at the beginning, I would like to highlight and clarify, do we consider what happened as a natural disaster or not? Because this is important on how you categorize the claim. And when you consider that it's a natural disaster, that's what might enforce or trigger the force majeure aspect. So what happened during the last circumstances, in order to consider that, does it reach to a level of considering it as a natural disaster? This would be determined by the country itself and by the designated authority. I know that we have in the UAE that there is the authority of the crisis and emergency, and this is the one who is determined whether that what happened is considered as a natural disaster or not. And what happened, just to clarify, it did not triggered as a natural disaster. It's just a heavy rain and bad circumstances of the weather that caused some issues, of course, what we saw on how it damages. Now, in terms of how is the civil law treat this, there is, as we know, two types of liabilities. There is a contractual liabilities between either we are talking about tenants and landlords. There is also between an owner and the contractor. There could be also an owner with the developers that they, in the way that they were purchased the property. And in addition to that, also, if we could take about the movals, because we saw major issues happen to the vehicles as well, where many cars have been affected by the flood of the waters. So in order to determine what type of claim that we need to rely or how the claim would be raised, they would be looking to the relationship that we are looking to it. If we are talking about a tenancy arrangement, what is the agreed between the landlord and the tenant? And beside that, once we go to this deeply, there is certain issues that elements in the law that need to be naturally provided under the contracts or even under the law. So any normal circumstances that if the landlord or the developer need to take care of any, let's say, conditions that the properties need to be in, all of these need to be maintained even under the law without necessity to mention it into the contract. So let's say that if there is any type of taking care of the drainage, the conditions of the property in terms of the normal maintenance, the coverage of all of the issues that need to be maintained once you provide it to the tenant, all of these are, even if it's not being mentioned by the contract, it is there into the law. So once we say that how this need to be, if there is any damages happened, how the claim should be, it is determined by, at the beginning could be by the contractual relationship between the parties, and then it could be also triggered to be extended under the tort liability if there is any violations of the rules that being provided by the law. So mainly this is how is the way that it goes, and I need just to, from the other aspect to say, if this is all being maintained by whoever the party, the obliged party, either it's a landlord or it's a developer or whoever is provided this, if it has been maintained and they did all of their what is provided by the law to do and that was out of their control, then here is it would be triggered that is they are liable to compensate or not. Was there any act of negligence from the person who's claiming itself, whether it's a tenant or it's an owner, from not maintaining the issue or not taking care or ignoring something that happened, like not to clean the drainage that he should be used with the way that it is, that the car he went into the let's say the floods of the water or whatever. That would be also determine how the court would treat the issue.
So we're saying really, if there's a contract in place, that's the most likely area to determine how the dispute will
Exactly, because it also would determine where we're going to go. Because if we are talking about tenancy contract, it's a different jurisdiction, which is with the center. If we are talking about purchase of a property, that's the court. And mainly, this is where it cook out. Where is the liability that need to look into it?
And I guess the question that a lot of people will be asking, if the contract is in favor, if the contract says a landlord or developer needs to maintain a particular thing, and he has maintained it, in that situation, would there be any liability on the developer or the landlord?
It's a tricky question and important. Now, he maintained it, but could be a technical aspect of that. To what extent he maintained it, and is it under the standards that is being required by the law or not? Because if let's say that the landlord provided that there is a good drainage and it was open and everything was good, then would be a technical aspect says that was this drainage is expected for such type of rain or not? Is it under the code that it's need to be in the property or not? Was it being fixed in a proper way or not? These all are different technical elements that can kick down. But yes, as you highlighted in general, if he showed that he did all what is required, then yes, that could trigger that there is no liability on that part.
And we know, Mohammed, that there's going to be litigation after this event, however you characterize it. What can developers expect in terms of what form that litigation is going to come, and how can they mitigate against it?
Okay, now I can say so far now we didn't see. We were checking with the different channels what's going, because the developers made a very good step when they announced that anyone who sustained damages the last time or facing any issues should communicate with the developer in order to see how they can. Many of the developers did this in the UAE, how they can mitigate the damages and how they can fix the issues. However, if let's say that this didn't happen, the developers need to first check whether really there was on their part a procedure that they should have taken, precautions that they need to cover in order to avoid such incident to happen. And if there was a part that non-compliance or let's say because of the circumstances they couldn't cover that one, they need to, in a way, in order to avoid, discuss with the claimant either they can, a way that they can reach for an arrangement, assume the liability in a part to avoid going into the litigation, and see how they can cover this or compensate it. Because it's, as you know, it's a continuous relationship. It doesn't mean that they still gonna, let's say if a person is living in a property, he would not just leave it, and if there is an owner of it, he will just, there is a continuous relationship. They don't want to have an issue between them. So it's better for them, and also from the image of the developer, also they are keen to show that they are providing the best quality properties, to take it and to see how they can assume it. However, if it's unfortunate, go to the litigation, a lot of technical issues would be kicked in order to decide to what extent they would be liable.
I guess that kind of feeds on to my next question. What people will want to know is, if I'm suing for this type of damage,
yeah,
is it a straightforward process?
That's a very important question, Andrew. It depends on a case-by-case basis. Some of them could be straight and direct because it's obvious. If we're going to say that property is completely flooded with the water to the first floor, there is something wrong, of course. But if we're going to say that there is just some electricity damage because water came into the house from the drainage, or there is a defect into the building, no, this is have a different element. There is a technical elements that would require an expert, and usually there's two types. It's either before you file the case, in order to see your position, go and consult with an expert to check, to determine where exactly is it my mistake that I didn't maintain the damage, I made this hole for the, let's say, the AC, an additional AC, and I didn't cover it well, which is go into the wall, or it's been by the construction of the building itself. This is better to be done before you go to the litigation, so the experts can give you an aspect. No, it's not your issue. It is the where, and this is can if you also give you an element to negotiate before you going to the case. And based on that, then it's gonna go to the court. And even if this didn't happen at the first stage, the court will by themselves also refer this matter to an expert to determine, check the circumstances, see what's happened, who's fulfilled his commitment or not, is there any breach of the liability or any breach under the contractual liability or under the law, and determine who did breach this and what is the compensation for that.
And you're an insurance expert. How does the insurance industry look at issues of physical damage caused by natural disasters or weather? How do they approach it?
I'll get to that in a minute, but just taking on from what Mohammed said at the beginning, right? What's the classification of the damage? That's very important. And on that, yes, we've not had any official communication, so to clarify this, but what the central bank did, which is the regulator for insurance authority, it has gone ahead and issued a statement which said that, okay, you're asking banks to give relief to customers paying home loans, and also then going on to say, if a car is insured under a comprehensive policy, then the rain damage cover is allowed. If it's a third party, then of course not. Similarly, they go on to say about homeowners and content policy as well. They've not, it still means that there are terms and conditions to be followed. It's not that it's an automatic route, but I think that question has kind of gone out whether it's a flood, because most of the policies that have been issued, the flood is an exclusion. And in a lot of the other jurisdictions, you will see flood is specifically bought. So it would be excluded, but what you can do is you can pay a certain additional amount and get flood damage included. And that's common where flood is a constantly occurring thing. So it happens on and again. But in this part of the world, nobody really thought that this is going to happen, and so nobody really cared to go ahead and get a flood cover. And now all the insurers were trying to use the flood exclusion, and the central bank circular almost goes down to say that no, you cannot really use that. I have to be careful here to say what I'm saying, but it almost says that. And that's very helpful from a policyholder perspective, because we're talking thousands of motor policies. We're talking that's the biggest hit number, right? Plus the property policies.
From my perspective as a real estate lawyer, I'm looking at certain parts of Dubai as having a real insurance issue now.
Yes, absolutely.
And I guess coming back to that circular, does that only cover that particular event, or is that going forward going to be applicable?
I think this was specific to the event. Specific to the event about those specific days. The rains happened that during days. Yeah. Any consequence of that, what's happened? To be fully honest with you, it targets more on the retail side of things. So it's talking more about the motor policy, homeowners policy, and not so much about the property policies and such. So that's again something we'll see how that folds out. But that's a good development in a way. At least brings some level of clarity. And on the insurance side of things, I think again, taking on from what Mohammed said, it goes on to the same concept. Law comes from logic, and insurance finds this a very similar ground. It says that just because you have insurance does not mean that you treat your property as if it's not your own. You have to do what you have to do to keep your property safe. And when you make a claim, we're gonna come and see that you've actually done what you would expected as a reasonable, prudent person to have done. And if that's not the case, then of course, they're going to use those arguments to not cover, and rightly so in some cases, right? So that's what the insurance overall position is in terms of property claims, that there were certain things that you were required to do. If you've not done it, then obviously you're going to get a pushback.
And what can insurers do to mitigate the liability here? Again, if we're seeing the circular as at least pushing out their exclusion, what can they realistically do in the future? Will there be more technical tests done on property? How does that?
Absolutely. I think then you have to now go back a few steps, and you're saying that, well, I did do everything, but still there's water inside the house. Yeah. It means there's a design fault. Yeah. It means there's an issue with the contractor, and you have to go back and identify those. And going forward, you're going to be much more careful. You're going to have those wordings included in your contracts with those people. And even now, I believe, let's say for insurers who may end up paying on these big insurance claims, because there's quite a few of them going around at the moment, and very big ones. And if they end up paying, they are going to ultimately go and find who designed, who contracted, who did what, and they may go after them as subrogated recovery claims, as you know. That's something that may come up because there is a fault, somebody has a fault, and at that level again, that designer may have a PI policy, so that may go back again to their insurer. But I would imagine these things will unfold as we go along. At the moment, we've also not seen too many coming to our desk, because right now, still in the notification stage, insurers are investigating. Until they say no, there's no reason for them to come to lawyers. So that's where we are in terms of these claims.
Thank you. And I think a question for both of you, really. And we act for a number of REITs, investment funds, all across the GCC, but specifically in the UAE. After these events, we've had a number of clients saying they've had damage to properties that they've invested in. What can those clients, those corporate blue chip clients, be thinking about in terms of getting compensation? Like we've touched on a few of the points, but if you were to go through a list of touch points, what would you say they should be thinking about and doing?
Yeah, from my side, or from, let's say, the disputes or litigation side, I think it's the first step is to discuss this issue with the related parties, whether it's a developer, whether it's a landlord, or whatever. Need to discuss and to see to what extent they are willing to resolve the issue. Now, sometimes it's in some circumstances you cannot look that you are looking for fully compensation, because as we know under the UAE, the terms of the compensations would be limited to the actual damages. So looking for a future losses or consequential damages might not be visible. And we could see some parts or some parties would try to just from the incident try to ask for exaggerating on the request for the compensation, which can reach for a block into the communication. So my advice is at least to be reasonable and sit with the other, because from the general view that we saw, everyone was willing to cooperate. Dubai also wanted to show that they are a good place, a good environment to invest, and they want to make sure that the investors are putting their money in a safe place. And all of them were willing to cooperate on how they can compensate any damages that could be happen. So it's the first thing. I think it needs you to quantum what damages happen to you, discuss it with the related parties that are going to be considered responsible, see where it's going on, and if this is not going to happen, or if there's something that need to be pushed back from their side, going to see or to go to the litigation part.
From the insurance perspective, I'm assuming you would advise, tell me if I'm wrong, having a dialogue with your insurer, like an open dialogue with your insurer.
Insurer as well as your broker, right? So I think, so far UAE has been a very vanilla product driven. So it's, if you think insurance, you think motor insurance, health insurance, property insurance, but there's so many different types of cover that's out there, right? So there are policies specifically designed for property owners, multiple properties owned by same. That's the issues of that, and that may go on to cover loss of rental as well, right? So let's say you have properties which were supposed to be on rent and now they're damaged, cannot be rented. That whatever the market rent is, you can cover it by the insurance. There are policies that tenants can take in a similar way. If the property that they're renting is unfit for usage, they can get compensated for it. They can get alternate accommodation for it. So there are so many new things that they can think of. Insurance can be a good support system for these things, and that's what the realization will come. And we are expecting insurance uptake to go up after this.
And do you see insurance legislation changing on the back of this?
Not so much on the legislation front, to be very honest with you. I think insurance legislations are generally very broad, because if you think about the amount of products out there, there's no way you can cover everything. So they rely more on the principles. They focus more on the principle of the insurance that yes, policyholders' rights have to be protected. This is how you manage your claims. This is how you manage your policy issuance. Not on policy level. So maybe not so much from driven from what incident happened, but I would imagine some clarifications coming up because the authority is going to be flooded with complaints if insurance companies are not playing. So they may come up with some clarifications on and try to find a middle ground.
And to follow on, and from, let's say, civil law aspects, of course, we don't expect that there could be change in the legislation, but it's an extraordinary, let's say, circumstances. However, as we can see, there is a change in the weather in the region, and based on this, what happened, the events that happened, I think there would be more discussions on the terms into the contract for that aspect, and more clarification on what's the obligations on, let's say, the owner or the tenant, and what is going to be on the developer or on the landlord, in order to make sure that if this is happened ever after, things are very more clear on each one obligations what to be fulfilled as well. We didn't see much contracts that talking about it before, but now after this, I'm expecting that part of the contracts would be having a specific part for such type of events.
Okay, well, thank you guys, and thank you for watching, guys. This will appear in our latest law update, which you can get online at LinkedIn and at our website. But again, thanks for watching.